Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Moraczewski, CRA board member and CEO of NMBL Strategies. Welcome. We're here today with Navigating Receiverships and with Emily Cantwell, fabulous attorney here in St. Louis. I can say that for a fact because she was actually my attorney in this case. So I am very biased, but I also think she did an amazing job as we walk through this. Emily, thank you so much for joining us. Can you give our listeners a little bit of background of who you are?
Sure, yeah. Thanks, Eric. Happy to be with you guys today. A little bit of background about me and my practice. So I'm an attorney with Lathrop GPM. I'm in our St. Louis office where I serve as the partner in charge of this office. Lathrop GPM, some folks might remember it used to be Lathrop Gage till 2020, and we have since gone through a name change. Headquartered out of Kansas City, but we certainly have offices across the United States. Stronghold here in the Midwest, but we've got offices in Boston and Washington, D.C., and California and Denver and Dallas and other locations that aren't perhaps historically thought of as Midwest locations. But in my practice, I am in litigation, but I really tend to focus more on financial services litigation. And sometimes that means also an emphasis on real estate litigation because it can be so often tied to one another. A bit of a unique area of my practice is that, as we're here to talk about today, I do work in the receivership world. I'm a board member with CRA, the Commercial Receivers Association, and have been involved in that group almost since its inception, not quite as long as you and Eric and Sinette, but have been involved for quite some time. But that unique area of my practice in the financial services world has allowed me to get involved in a number of different cases in a number of different ways in the receivership aspect, which I think is only going to be growing as an area of law and a tool that both courts and parties have available to them as we look to help out companies, or in some instances even individuals, work their way through situations that are potentially unique and outside of the normal when you think of litigation.
Well, thanks, Emily, both that introduction for yourself and for Lathrop. So kind of with that, we'll dive a little bit into the case at hand. So the case that we're here to talk about today is CannaVer LLC. It was the first cannabis receivership in the state of Missouri. Also, a little bit unique facet in this is we came in as team number two. The initial receiver had actually taken ill and had to step away. And so we had to step in and do a number of things that ended up generating substantially more for the estate than what was initially planned. Talk to us a little bit about CannaVer, what brought them into receivership. How did we get to that point?
Yeah, and I'll take just a couple of steps back because I think what brought us to CannaVer being in receivership was a very macro level, two important pieces of, I suppose, litigation or legislation or legislative history. The first being that the Missouri Commercial Receivership Act, which was passed, I believe, in 2017 and went into law, I believe, in August of that year. So that, of course, created a statutory framework for receiverships in Missouri that had not been there in the past. We had what is referred to as common law receivership, meaning that would be laws that are created out of the case law that's developed into our state. But with the passing of the MCRA, that allowed for a statutory framework, and what it did is it really put pen to paper for a more uniform way to handle receiverships within our state. And so we went from trying to decipher through years of case law as to how receiverships were to look to really having a framework that followed quite closely the federal framework and some other states in the Midwest that I believe I'm correct in saying the authors perhaps borrowed from and looked to when developing Missouri's act. So that went into effect in the late 2010s. And then the other, of course, big piece of this is that recreational marijuana was passed in Missouri a few years ago. And so that opened up the floodgates really to a number of new businesses, a number of new regulatory schemes, a number of new problems that oftentimes happens when you have these businesses in these types of industries where there's going to be a lot of cash and a lot of regulation. And so those are kind of the very two high line item structures that really brought us to how did this receivership with CannaVer come to be. And so CannaVer LLC was a limited liability company that was started in Missouri a few years ago. It was started, as I believe many of the cannabis companies did. There was initially, a push by the first one or two owners to really gather together a number of funds and get together essentially a pot of money to start this business. The initial owners were in fact successful. They were able to raise quite a bit of capital in the name of CannaVer LLC from a number of different investors, both individuals and entity investors. And they went about with this raised pot of money that they had gathered to build what some might call, the Taj Mahal of a space for cannabis, for the manufacturing, and then ultimately, of course, the selling of cannabis. And I think that's really where the problems came in, is that while the owners had done really a good job at raising these funds, the expenses which were going out the door specifically to build this facility for themselves and for CannaVer really it outpaced what they were able to bring in on the funding side. And so what ended up was that they had this very nice building with liens which were attached to it from the various contractors, and also none of the raised funds which they originally had were left because they had all been spent building this building. And as you have said previously, there was not a rainy day fund. And so they really didn't have any working capital left. They had this building, but no working capital. And what resulted was, over the course of 20 months or so, and you can correct me on this number, I believe, 120,000 in sales. And that would be it for almost 2 years in operation. And so, as you can imagine, that's just not going to keep any business afloat, but much less a business that had the expenses of CannaVer being an early business, being responsible for loans to repay what it took to build the building, responsible for the ongoing operating expenses for a company like this that's going to be highly regulated. It's going to have additional expenses from perhaps what you would normally see from what I might call, a mom and pop shop. And so without the money, as you might imagine, things got difficult between the owners and the investors. And ultimately, there was really a deadlock between all of the groups with any interest in this company. And so ultimately, one of the groups that had an interest in CannaVer elected to put it into a receivership. I believe it was an emergency hearing to put it into a receivership, and it was granted. And that was back in 2023. We did not get involved. You did not get involved as receiver. And of course, I would not have gotten involved as your counsel right away. I believe it was another year, maybe even almost a year and a half before we got involved and really became the receiver of CannaVer. But in reality, and technically, we were always the successor receiver because the initial receiver had stepped down.
I forgot until you said it, but the first group I ever toured through and potentially selling to them walked through the facility, and the first thing they said to me, they said, this is the Cadillac of facility build-outs. And so the next group I toured through, I said to them, I've been told this is the Cadillac of facility build-outs. And he turned to me and goes, this isn't the Cadillac, this is the Maserati. And so everyone was so impressed with the high-end build-out of it.
Yeah.
But obviously, if you don't sell and don't generate revenues, and you don't have a rainy day fund,
right,
you're going to be in for a difficult path, even if you do have a really nice facility. And that is really what did end up, like you said, bringing it into the receivership. So we got involved. Walk our listeners through a little bit of what we did as a successor receiver team as we led this through. I will say we had a judge that was great to work with as a part of this case, because it did go on longer than maybe we initially thought we'd be in it for, but I think that did help, having a good quality judge that would listen to it.
Yeah. So what we did when we got in, I mean, there was a lot to do. One of the issues that we had to get our arms wrapped around was that there is this receivership that named only CannaVer LLC as the entity which was going to be placed into receivership. there was another entity, which was, it's a long name, Guarantor Real Estate Holding Company, I believe was the entire name. It was another LLC that was tangentially related to CannaVer, but GREC, as we came to call it, was not placed into the receivership. And so what we had to get our arms around was the relationship, if any, between these two entities. And to go one step further, the relationship of these two entities with the actual owner of the property that was, the Moraczewski property, the tenants that had previously been in this property, and how are we going to handle this situation with varying interests and ownership interests when the only entity that we were charged with was CannaVer. And so there was this mechanics lien case that was also pending in St. Louis County Circuit Court, which is where our receivership case was pending. But there's this mechanics lien case that was pending that would ultimately impact our case because of some of the fights going on in the mechanics lien case and who was going to be considered the senior lien holder of the property, which was involved, again, somewhat indirectly, but involved in our receivership matter. So we had to get our arms wrapped around that. How are we going to handle that? How are we going to market this situation to potential buyers, knowing that there's this other situation out there? So that was one of the big issues that we had to get our arms around. Another very immediate issue that we had to deal with was the fact that the prior receiver to us, our predecessor receiver, had the assets of the estate that he was in charge of and he was responsible for as he was named receiver, which included 3 manufacturer's licenses that had been awarded to CannaVer, and it also included 5 appeals, what we called appeals, but they were 5 licenses that were not awarded to CannaVer, but CannaVer had the appellate rights to their not being awarded those licenses, which actually had a value to them, these appellate rights. And so when we first were appointed, the predecessor receiver had filed a motion for the court to approve the sale of 2 of the 3 manufacturer's licenses, because one had been previously sold by the predecessor receiver, and also the appellate rights, and also an interest in this property that was hung up in this mechanics lien action. And so that was technically a pending motion before the court to sell all of these rights and these interests and these assets to a buyer, third-party buyer. And upon us getting involved, we pretty quickly looked at the terms of that sale, and we did not think that would be what would be best for the creditors of the estate, which is really, as a receiver, you are charged with, among other things, looking what's going to be the best for the creditors or those interested in the estate, and what, in the right receivership, what actions need to be taken to liquidate the assets to best benefit those creditors or entities which are interested in the estate. And when we looked at the predecessor receiver's motion to sell, we did not think the sale terms were going to reach the standard that we thought was going to be required of a receiver. And so we had to quickly, because the hearing date for this motion was in short order after we were appointed, we had to withdraw that motion and really go back and look at how are we going to structure our own sale to make sure that we were liquidating these assets and getting the most out of these assets for the creditors and the parties that were interested in the estate in a way that was going to be a little bit different than what the predecessor receiver was offering. And so that was something that we had to move pretty quickly on, just to make sure, like I said, that we were really, protecting the estate in the way that we were charged with as the named receiver. So those were the 2 kind of big things early on. And then, of course, all the other requirements of a receiver, we need to send out notice. We ultimately need to set and went through a claims period, which took a lot of time because there were a number of claims. And in this case, unlike some receivership actions, there were actually going to be distributions. And so interested parties certainly were going to be able to have the opportunity to receive their share. If their claim was proper, we needed to get information out to the correct taxing authorities. We needed to set up a platform by which we could market the assets, and that you could, as you said, walk folks through once we reformatted our sale to make sure we were doing as much as we could to get the highest liquidated value for these assets. So that was all early on in early days of the things that we had to do. This case was interesting because everything that I just described, fairly typical, what you would see in a lot of receiverships. You're looking at the assets, you're analyzing the assets, figuring out how are we going to sell this stuff, what's the best way forward. as this case progressed, we found ourselves dealing with various governmental entities with the state of Missouri. Of course, we were dealing with the IRS. We went up and down into the appellate court within this case, which was interesting. And for being the first cannabis case in the state of Missouri, we provided a lot of different areas of law that all of us got to be involved with, and we got to help work through with the judge to get this thing to finally to a place of resolution, which also somewhat interestingly ended with a mediation, because we needed to get an issue resolved with regard to the mechanics lien case that would impact our case. And the parties came together and thought mediation would be the way to do that. And we in fact did that with the help of a local mediator here. And he helped us get this case to a point where ultimately we were able to resolve the case. And you were discharged as a receiver about a month ago.
Yeah, I mean, you covered a lot there.
Yeah.
Because it was a busy case, and
Yeah.
so many things happening in that we had lawsuits going on to closely held entities, but not necessarily the entity in receivership.
Right.
We sold assets like the property free and clear of all liens, despite the fact that it wasn't in the receivership granted by the state, and ultimately worked out a negotiation with creditors to make sure that that was possible. So it did have a lot going on. Tell me a little bit about some of those moments that even just kind of kept you up, like worrying about it. Because I know I called you on one like 2 days before we closed out the receivership.
Yeah.
But I'm sure you had a couple that you were like, is because we're setting the pace for being the first cannabis receivership, were there concerns that you had as we went through different areas?
Yeah. I mean, I don't know about concerns, but yeah, I mean, the reality is that we didn't have precedent to look to say, how has the court handled something like this before for nearly every single decision that we were making. And again, we had the statutory framework, which thank God it was there, and that helped to guide us. But the issue that we went up into the appellate court with was as to how the court handled one of the claims by a creditor who we argued was not technically a creditor of CannaVer. They, of course, were arguing that they were, because they saw that there was going to be a distribution of funds. And so you certainly could understand why they wanted to come into the case and be a creditor of CannaVer. And we simply argued that they were not, based on any number of issues. And that is a situation that it went up to the appellate court. And I think it's interesting, if you were to listen to the transcript of the appellate argument, the judges there voiced some frustration about perhaps, the Commercial Receivership Act in the state needed some tweaking, because the questions that we had and that were being presented to the court weren't handled in the act, and there wasn't precedent to look to. So even though the appellate court helped to make some precedent with the opinion that they came out with regard to this, how the court handled the claims and our arguments and the other side's arguments, there just wasn't precedent to look to say how have the courts handled this before, which is typically, as a litigator, that's what you're always looking for, is how have the courts handled this before, or has there been a similar situation that we can find analogous here. And because of the newness of both the Commercial Receivership Act and of course recreational cannabis, and these two worlds meeting, there wasn't that type of literature or education out there. So that was always something, that we were coming up with, original arguments on a lot of what we were doing. And the fact that, it was the first cannabis case. So we were really setting the tone, and knowing that, as we were going through our case in St. Louis County, there were other cases that were percolating up in both St. Louis County and certainly I'm sure other jurisdictions around the state. So that was always something interesting.
One other area that we went through that I always found interesting was, and you touched on briefly, was the appeals and the appeal rights.
Yeah.
We went through a period of time where we had engaged an attorney to pursue the appeal rights and try to transition those into licenses, which would have been worth significantly more than appeal rights.
Right.
We had a period of time where we thought that we had a legitimate shot at winning those appeals, but case law changed about a month or two before our hearing on those, that reversed where we felt we would win to where we felt almost certainly we would not. And so we reversed path and then just decided to sell the appeal rights to others in the industry who
Right.
were aggregating enough appeals together that the state would award a license. And we ended up with a really good sale out of it. They were typically selling for about
Right.
$50,000 per appeal, and we sold ours for closer to, 200,000+ per appeal.
Right.
So
Right.
we ended up with a pretty good last second pivot
Yeah, and
out
it
of it
was
all.
last second. I mean, I remember that we had filed a motion for some approvals related to the appeals, and then, I mean, really at the 11th hour before our hearing date, we were advised by counsel who was handling the appeals within the administrative division that what we're asking for was not going to be, to the highest benefit that we thought we could get for the estate. And, at that point in time, we had to pivot quickly. We had to do some changing, certainly of the sale motion, of the sale procedures, of what we were asking the court to approve. And that was one of the moments where the benefit of us working with the creditors throughout the case came through, because I emailed the lawyers for the other creditors and I said, here's what's changed. Here's what we're going to ask the court for tomorrow. I don't want anybody to be surprised, but this is what we think we're going to be able to do, but we have to move really quickly. So if you're going to object, go ahead and let us know, because if not, we could really be out of time. And we were able to do everything that we needed to do. We were able to turn around a sale. If I'm remembering correctly, it was in 7 or 8 days. I mean, it was very quick. Very quick. And we worked with the court to make sure that we got everything, filed that we needed to get filed. And then we were able to consummate that sale, much quicker than we really had even originally intended, but it's what we needed to do to make sure that we could get those proceeds into the estate. But yeah, that was 7 or 8 days of really quick, fancy footwork for sure, because things had changed. I mean, if I'm remembering, it was almost overnight. We got word that there had been a change. We had to change our motion, and we did, and it worked out. So that was nice.
Yeah, it definitely made sure that we stayed on our toes
Yeah.
during that period, but ultimately yielded maybe not the best result, as the best result would have been winning the case, appeals and selling those licenses for their market value, but the best result that was possible with the information we had at the time.
Right. Yeah. And one thing I think all litigators think about, and certainly I do, is that there's always the ROI analysis that you have to go through, right? And what would be the return on investment? And when you're counsel for a receiver, and when you are a receiver yourself, as you well know, you have to think about what is going to be the best for the estate, and what is going to, as a fiduciary, what is going to put you in a position where you're making the best decisions for the estate. And at that point in time, the percentage of us winning, on the appellate argument in front of the administrative division had dropped significantly, not through any actions of us whatsoever, but just because the landscape had changed. And so it was the prudent decision to recognize that and to not take on the risk with other people's potential distributions, because that's exactly what we would be doing. And to say, look, we think that the most prudent choice here, and the smartest choice, and the most risk adverse choice, which was the appropriate decision to make. Sometimes risk is good. Here it was not, was to go ahead and go through with those sales.
And ultimately, between the sale of the primary assets that were initially sold in that, when we took over, an offer that was on the table for everything and sold it for about 56% more than what was originally on the table.
Yeah, and importantly, we sold it for cash. There was no financing.
Yeah.
And that was a big difference from the offer that we were handed when we became the successor receiver, was a financed option. And really, it was seller finance, if I'm remembering correctly. And we took from that position to everything that was sold for cash. And then the amount and the value that we were able to derive from the sold assets was higher across the board.
So yes, we took that into cash and turned that around to distribute to equity holders. So hopefully, while there was a moment in time where we thought we might even make distribution to equity holders, if we had won those licenses,
Yeah,
we still came out much further ahead for the unsecured creditors, which were at basically a point of a zero return.
right,
We
right.
stepped in
Yeah,
to getting 50 to 60% of their
yeah,
unsecured claims paid out.
right, right.
So hopefully, even if it's not a truly joyous moment for everyone, it's a better moment than it was when we first stepped in. What were kind of some of the things that you feel like wrapping up the case, you look back on and go, that's a lesson that I've learned, or that's a lesson that others should take away from this that maybe would be of value?
Yeah. Yeah, certainly the education piece, and that's across the board. And by that I mean, educating or understanding that when you're in these types of receiverships that are unique or new or have no precedent to look to, that it will be the job of the receiver and thereby the receiver's counsel to serve as an educator of potentially, administrative officials, of potentially other lawyers, including creditors' lawyers, who just simply have not dealt with state court receiverships, just of your own client, or the debtors or whoever the case may be, that you may well be in the position of educating and then sometimes learning together as the case goes along. So that was certainly something, that I noted in the case, and that'll change, as there is more case law that's developed out there and there is more historical references that parties can look back to. There probably will be less of that as everybody gets more familiar with what receiverships are and what they are not and what they can and cannot do. I think that'll decrease some, but there certainly is the education piece when you've got lots of newness, both in the statutory framework and the subject area, in this case cannabis, that you're dealing with. So that was something, certainly, that I took away. I mean, this case required some patience. Receiverships oftentimes are quicker, certainly much quicker than commercial litigation. You can get in and out of receiverships in sometimes, as little as 8 to 12 months. This case was filed in 2023, and it was really just finished up maybe 2 months ago, but in spring of 26. So this one was a longer one than most, so there was some patience required of it. And like I said, the fact that we have this kind of sister case going on that really did impact our case required some patience, and also working together with other lawyers to try and get this thing to a conclusion. I think it's being ready to think outside the box. The fact that ultimately we were at a mediation, not because any of the parties were really warring, but because we needed a third party to come in and help us say, okay, A, B, and C, this is how these things are going to work. Can everybody deal with that to resolve this instead of continuing to litigate? I mean, that I don't think mediation is something you necessarily always hear about in receiverships, because the receiver does have such a power that's derived from the statutory framework. But in this case, thinking outside the box and going to mediation and having that third party perspective, I think also it was really helpful. So, just keeping that in mind, that sometimes you have to, that it's not going to be a straight walk. It can be a bit of a curved walk, but you'll get there, and thinking outside the box can help you get there.
Something I just thought about, kind of that thinking outside the box and working with so many parties that we haven't even touched on, but this was a case brought by the equity holders, but there was secured debt in the case.
Yeah.
And the secured debt was sold, I believe, at least twice during the course of the case.
Yeah.
And that the banks were purchased, or the credit union was purchased
Right.
times. And so working with the new groups on what was going on, also on that education side, kind of kept having to play a role, because we had to keep going back to, okay, here's what's gotten us here. Fortunately, I think the last group that ended up being the owner of that debt did not fall into that old saying of, pigs get fat and hogs get slaughtered, because they easily could have, being the largest debt of the creditors, but because they didn't, and because they reached an agreement through that mediation, I think we were able to put this behind everyone and move forward. That had they wanted to really be humongous pricks they could have, and we would still be dealing with a case right now.
Yeah, I mean, I think that goes back to that ROI. I mean,
Mhm.
it is something that lawyers, I think, many times, I mean, that has to be part of your analysis is that, there is risk and there's reward. And, how are we going to handle this situation that if we aren't able to resolve it today could really span out for another number of years? And is that really what's best for your client? And so, yeah, there's a group of us who's, I mean, December, I mean, it was right before the holidays, so people were certainly busy with lots of things going on, but we were able to come together. And then a week later, right before Christmas, we were able to get the court to bless, the mediation and the settlement, which is a little bit different because typically courts don't really know what's going on. If there's a settlement, they're not really supposed to know. But in this case, the court needed to know because of the requirements under the receivership order that the court would approve these types of big decisions in the case. But we were all able to get in there, sophisticated lawyers on all sides, which certainly was helpful. And we were able to resolve the case.
Is there anything you want to leave listeners with before we go?
I don't think so. I mean, it was a fun case. I don't typically touch on as many areas of law as I did in one case as we did in this case. But no, it was a fun case. I'm glad that we were able to bring it to a resolution. And I do think it's one of those cases where, all parties, if not most of the parties, perhaps, I think we're really happy with the ultimate resolution and how we ultimately ended up concluding this case, which is always a nice feeling.
I almost forgot, and I'm so glad that I remembered. Probably the only time in your career you will write a motion to destroy 3,000 vape pens
Yeah.
that were required by the state's cannabis regulations, that we had to go into court and explain to the judge why we're destroying 3,000 vape pens, in which I had to take a hammer to all of them, which
destroying of vape pens, and if I am recalling correctly, we had to dump the contents, or kitty litter was involved in some way, shape, or form. And so I had to go in front of the presiding judge of St. Louis County Circuit Court, which is the largest circuit court in the state, and ask him for permission to utilize kitty litter to destroy some of the vape pens because they were technically property of the estate. Yes.
Yeah.
Yes.
So we did get to touch on a lot, and it was so much that I often forget all the different things that occurred.
Yeah, certainly.
Yeah.
So, but no, it was a fun one. So looking forward to the next one.
Well, thank you, Emily. I appreciate your time today.
Great. Thanks so much. Have a good one.
Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.